One, two. Is this on? Today I want to talk about a hobby of mine. I've been interested in copyright law for decades now. The nuance and the differences and the changes over the years have kept it an interest since the late 80s when I questioned how both Marvel and DC Comics could have characters named Captain Marvel who were so similar but also so different. Copyright is far more intricate than most people give it credit for, so I'm just going to focus on one aspect today: the public domain. Works published in the US are in the public domain if they are not covered by copyright or if the intellectual property rights have expired somehow. There is a federal agency called the United States Copyright Office whose purpose is to keep track of copyright records. Because of the changing copyright laws in the US, there isn't a blanket coverage for when a work enters the public domain. A good rule of thumb is that anything published before January 1st, 1931 lost their copyright protection by January 1st, 2026. There are exceptions, of course, which is why I say it's a rule of thumb, not just the rule. Any work published before January 1st, 1978 that didn't have a copyright notice are also in the public domain. Works published before 1964 entered the public domain if they were failed to renew the copyright in 1992. As I said, exceptions. In the US, as I'm sure you already know, we both have state laws and federal laws for different aspects of legal matters. Before 1787, some states had copyright laws, but there wasn't federal protection at all. The Copyright Act of 1790 set copyright protection at 14 years with the possibility of a one-time renewal of an additional 14 years to extend to a total of 28 years of copyright protection. There were many extensions, but few major changes to this protection for almost 200 years afterwards. The entire system for copyrighting work was overhauled in 1976, which I think I've mentioned before. Because of continued modifications, very little in the US entered the public domain from 1982 all the way to 2019. Most of these modifications appear to have been to keep a specific creation covered by copyright protection: Steamboat Willie. Steamboat Willie was premiered at Universal's Colony Theater in New York City, 1928. It entered the public domain in 2024, 98 years later. Laws had changed to keep the animated Steamboat Willie from entering the public domain as scheduled in 1955, 1986, 2003, and 2023. A Disney researcher named Gregory Brown suggested in the 90s that Steamboat Willie was already in the public domain due to errors in the original copyright. This would have been under the rules set in 1909. Disney threatened to sue a Georgetown University law student who published a paper confirming Brown's claims for slander of title, but did not want the situation argued in court and so did not carry through with that threat. It has been argued that political pressure applied towards Disney in the early 2020s is what prevented another legal change to extend copyright protection. And Disney's use of Steamboat Willie as a logo starting in 2007 will keep their ownership of the character as a trademark as opposed to a copyright going forward. In addition to works entering public domain due to expiring copyright protection, there are other ways for something to be public. Works produced for a company allow that company to own the copyright, but works produced for the U.S. government are automatically in the public domain. This includes military journalism, federal court opinions, census data, congressional reports, etc. Works created by a contractor for the government, instead of directly for the government by a government employee, can be copyrighted by that contractor. Again, a lot of exceptions to every rule. Having a work in the public domain is always good for society, I believe, because it means that work can be shared to a wider audience easier. It also means that derivations of that work can be legally protected. The entire genre of fan fiction is a borderline public domain issue that I do want to delve into more in a future video. In addition, having a work in the public domain can also be a good thing to the former copyright holder and the people who worked on that project. The movie It's a Wonderful Life entered into public domain in 1974 because the copyright was not renewed. This meant it was free to broadcast, so many stations ran it as a Christmas movie for years. This took a movie that was only 26th at the box office and placed it solidly into the public consciousness as a holiday film. In 1993, Republic Pictures was able to use a prior Supreme Court ruling to reclaim copyright protection over the movie. So currently, Paramount Pictures owns the film, which is why it's no longer shown on broadcast television across multiple networks every Christmas. But had it not been in the public domain and therefore cheaply able to be shared for those years, it arguably would not be as popular or as profitable as it is currently. What are some public domain works you know about or would like to know more about? Do you have questions as to whether a certain book, paper, movie, or recording is currently in the public domain that you would like me to research and talk about? Leave me a message down in the comments below.